Good morning. Welcome, everyone. Thank you for your patience this morning. And welcome to this session of the Court of Claims. We are here for case number 25-175, which is Macomb Intermediate School District versus State of Michigan. If I could have the attorneys put their appearances on the record for me, please. Good morning. Morning.
Your Honor, our other colleague Ahmed Shihab and Macomb.
Welcome. Good morning.
Morning, Your Honor. Adam DeBear on behalf of the state of Michigan.
Oh, good morning. Welcome. We are here today on the parties' cross motions for summary disposition. At the outset, I want to say thank you for your wonderful work on this case. I know I set some very stringent briefing deadlines, and you met them with grace and have provided me lots of really good work product to work from. So I really appreciate that. With that, in terms of the process for going through these motions, I figure we'll let the plaintiffs go and then defense and then reply. Sound good? Okay, please continue.
Good morning, Your Honor. May it please the court. Again, Scott Eldridge on behalf of the plaintiffs. I also would like to take a minute just to thank Your Honor and the court for being so attentive to this matter and working with the parties to expedite your consideration of the merits, knowing that there's a looming statutory deadline at the end of the calendar year here. And I also would like to commend my friends on the other side for their cooperation in working with us to tee this issue up for you for a decision. It's refreshing that when opposing counsel actually work together to accomplish goals, even if they're scheduling goals nonetheless. So thank you for your professionalism and cooperation. Your Honor, this case is about legislation, and we're asking Your Honor to declare, of course, a sliver of a statute unconstitutional for a variety of reasons under the Michigan Constitution only. This was rushed legislation, and rushed legislation often results in bad legislation. Here, Public Act 15 of 2025, which includes the problematic language subsection 31AA subparens 9, that's specifically at issue, and which we have been referring to as the privilege waiver. And I'll use that moniker throughout my presentation today. It resulted in language that violates the Michigan Constitution at least 3 ways. It was so eye-poppingly bad language that it garnered so much attention right away that we had to turn plaintiffs away from being involved in this case. And we have about roughly 40 separate school districts and ISDs who are named plaintiffs, with an equal number of individual superintendents and other school officials who have been named as plaintiffs. And on top of that, you've heard from almost 200 separate school districts who signed on to an amicus brief that was filed in support of our position and against this unconstitutional language. And it was so eye-poppingly bad, this language, that 2 of the defendants in this case, the state superintendent and the Michigan Department of Education, the 2 defendants responsible for enforcing and administering this statute, are not defending it. The legislature's desire, of course, to provide funding to schools for school safety and mental health is a laudable goal, but they still have to work and operate within the confines of the Constitution. And so for purposes of evaluating, of course, the statutory provision, we in the court, we don't examine whether it was well-intentioned or even if it was just sloppy language. Instead, we have to examine it, that is the statutory provision at issue, against the requirements of the Constitution. And the sliver of language that we're asking Your Honor to declare unconstitutional for a variety of different reasons is, as I alluded to, embedded in section 31AA subparens 9 of the School Aid Act. And that provision says, quote, to receive funding under this section, a district, an intermediate school district, a non-public school, or the Michigan Schools for the Deaf and Blind must agree to be subject to a comprehensive investigation, must affirmatively agree to waive any privilege that may otherwise protect information from disclosure in the event of a mass casualty event, and must agree to comply with a comprehensive investigation, end quote. Subparens 9 goes on to explain a little bit what the legislature means by comprehensive investigation. But the privilege waiver provision that's at issue in our complaint in front of you today is that middle part that says, quote, must affirmatively agree to waive any privilege that may otherwise protect information from disclosure in the event of a mass casualty event. The phrase any privilege, of course, is not defined in the statute, nor is it limited in any temporal scope or by context. And the definition of, in the phrase mass casualty event, which is coupled with the privilege waiver and is part of the privilege waiver, is then defined in subparens 12 of section 31AA. And those definitions, which we'll expound upon shortly, are also exceedingly vague. And so when you couple the any privilege provision or language with the mass casualty event language, per its definition, you have the constitutional problem that's in front of you. And it's that phrase that we're asking your honor to declare as unconstitutional. We're not asking you to declare as unconstitutional the entirety of subparens 9, just the phrase that we refer to as the privilege waiver. Each of the constitutional violations here present separate independent reasons for you to declare that provision unconstitutional. And I'll walk through each one. Now, if this language, though, your honor, is upheld, school officials will be forced to decline significant school aid meant for a good cause, but out of concern and uncertainty created by this overly vague language. The language effectively coerces school officials to waive any privilege in any limitless number of contexts, seemingly. And thus, they're not really knowing what they're getting themselves into if they agree to opt in under these conditions and receive this money. And so that leads me to the first constitutional violation of substantive due process that I want to address with you. Our substantive due process claim is one that is referred to as void for vagueness. Our argument is that the privilege waiver is so overly vague that it's void and unconstitutional, precisely because it doesn't give enough direction to school administrators who are responsible for invoking privileges in various contexts throughout their day and throughout their job administering and overseeing schools.
So Aldrich, how do you respond to the state's argument that the privilege waiver isn't vague? It's so much as it just is broad. It's any privilege that can hinder this information.
So any privilege is not, just the phrase any privilege is not the problem. The whole clause is our problem and is the constitutional problem. Any privilege in the event of a mass casualty event creates the problem, that whole sentence. A statutory provision being broad is different than it being vague. Something is broad means it could encompass a lot of things, but has limits. Vagueness means it's limitless and unbound because it gives zero guideposts or direction as to what's legal versus what's illegal conduct. And that's the hallmark of a void for vagueness argument.
So what they're saying, that the language at issue is waive any privilege that may otherwise protect information from disclosure in the event of a mass casualty event. That's the language, just
correct,
right? Okay. And so what is, explain for me the vagueness versus like,
right.
what are you, that the guardrail isn't there in terms of what this information would be?
So the void for vagueness doctrine, as interpreted by Michigan courts and as we've cited, and other federal courts, as we've cited in our briefing, Your Honor, it guarantees that individuals receive fair notice of what the law requires, and by preventing arbitrary and discriminatory enforcement. That's the standard that we have to utilize. So, it's stated another way in the briefing as we presented to you. It has to, the language to avoid for vagueness argument has to give a person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he or she may act accordingly. This fair notice requirement is not satisfied by this particular language. So any privilege could be as broad as, even though it's not defined, statutory privileges, common law privileges, constitutional privileges. And if there are other privileges out there, maybe those too.
Definitely attorney-client, work product, all
Absolutely.
of that stuff.
All of that would be encompassed in this. Common interest privileges are a thing in litigation. That's also another common law privilege. But any statutory privilege that might apply has essentially been eviscerated by this language in the event of a mass casualty event, whatever that means. And we'll get to that in a minute. So you can see already just by looking at the any privilege language that we're starting to guess as to what privileges apply.
I guess the part that I'm having trouble with is that we're not guessing, we're enumerating the privileges that we can think about. I think that the phrase any privilege encompasses all of them.
Well, it may.
Okay.
And it may. It's not clear from the statute that whether it does and to what extent it does. Whether it applies to individual privileges is unclear from the statute. To what extent is a waiver being effectuated? Is it just a waiver of the school's privileges? Is it just a waiver of the district's privileges? Is it a waiver of the school officials who rely on those privileges as well? Can they invoke privileges with their own attorneys in circumstances that might be triggered by a mass casualty event? That's still unclear from the statute, but I understand your point. Any privilege means any privilege. Breadth alone doesn't necessarily mean vagueness, but when you couple this any privilege language, which we think is vague and broad in and of itself, with the in the event of a mass casualty event language, that's when it really becomes constitutionally problematic, because that provision, mass casualty event, is defined so vaguely that it is almost limitless. We've provided as many examples as we could think of as to how this could be triggered and in what circumstances, that we don't think, but we don't think it's a finite list of circumstances, because it could literally be endless given how broad the mass casualty event language is in its definition. But I want to highlight a couple of other points about the problem with the in the event of a mass casualty event language. So it says in the event of a mass casualty event. It doesn't say in connection with a mass casualty event. It doesn't say related to a mass casualty event. It just simply says you're waiving any privilege in the event of a mass casualty event. So if you have a mass casualty event, however broadly that is defined, and whatever that might be, and again, that could be limitless, have you now waived any privilege that applies to any circumstances, even unrelated to the mass casualty event? This is how sloppy this language is, how exceedingly vague this language is. In the event does not mean in connection with or related to, nor does the waiver of the privilege apply to a comprehensive investigation. That seems to be one of the arguments that my friends on the other side are making on behalf of the state, that this is, you can construe this as being limited to just the comprehensive investigation language that's in subparens 9, but that's not what the language says.
So
This
would
would apply to
that be saved by any of the, rules of statutory interpretation and my obligation to read a statute in a way that is constitutional? Would it be saved by any of those canons?
I don't think it is, because you just have to start with the plain language of the statute, and that's where you start and that's where you can end. I don't think you have to think very hard to realize that this is in fact boundless and limitless, and that's the constitutional problem. And I want to get to the mass casualty event piece in a second, but I think it's really important to note that this language, because it says in the event of a mass casualty event, is not related or limited to the comprehensive investigation. We're talking about any other type of proceeding where a privilege might be invoked. So civil litigation, criminal investigations, Freedom of Information Act requests, Open Meetings Act. School districts rely on a privilege, like an attorney-client privilege, like a work product privilege, in civil litigation all the time. They rely on it to have candid conversations with their attorneys. If now a mass casualty event has occurred and now we've waived any privilege, if there's civil litigation related to this mass casualty event, which invariably happens, now your attorney-client privilege is blown up. You cannot invoke it under this waiver. At least that's one instance.
Would in the way that you're reading the statute, would it also be fair to say then that the waiver is not connected to the mass casualty event either?
Correct. The waiver, not by the language in the statute. It's
So it could be a waiver that has nothing to do with the mass casualty event, but a waiver that has to do with something else?
correct, because the language says in the event of a mass casualty event. I think that's how vague this language is. If I were a plaintiff's lawyer wanting to sue a school district after a mass casualty event, that's the argument I would make. Because the language suggests that that's what it encompasses. But we don't know, and that's the issue. And that's why this is void for vagueness. School officials who are responsible for invoking privileges, whether it's in civil litigation, whether it's in connection with an investigation, whether it's in response to a FOIA request, need to know what the parameters are. And that's what creates the constitutional problem here. Coupling that with the potential criminal exposure for these school officials who are responsible for invoking privileges in all these various contexts requires a heightened scrutiny by this court under the void for vagueness doctrine. And we've cited authority, Your Honor, to that effect. And that's what happens here. Section 161 of the School Aid Act, in which 31 AA subparens 9 is embedded, makes it a crime for a school official to violate the School Aid Act. And so this is really the issue for these school administrators. Even if, and I think this is a big if, even if the waiver is a waiver of the school district's privileges or the intermediate school district's privileges, which I think is one of opposing counsel's arguments, they still don't have the requisite guidance as individual school administrators to know when it's proper to invoke those privileges or when it's not. And if they get it wrong, are they violating the school code, or I'm sorry, the School Aid Act in such a way that it amounts to a crime under 161 of the School Aid Act? That is the that's what requires a heightened sense of precision in language, is when you couple it with this criminal exposure. We cited to a case, Your Honor, from about 10 years ago out of the Eastern District of Michigan called Taylor versus Johnson. Happened to be a case I handled where we sued the Secretary of State over a recent change to the Section 57 of the Campaign Finance Act that prohibited school officials and other elected officials from commenting on ballot question proposals the 60 days before the election. We challenged it on a number of constitutional grounds, and Judge O'Mara in that case issued a preliminary injunction because on our argument that it was void for vagueness in violation of substantive due process, similar to our argument here, and applied a heightened scrutiny analysis to it precisely because it was also a crime to violate the Campaign Finance Act. And it was so vague that no one knew what was legal, what was illegal, and the exposure to the potential criminal penalty was real enough to require heightened scrutiny.
I was looking at the Taylor case, and the one thing that I've been struggling with in this argument is that the waiver very clearly applies to a district, an intermediate district, a non-public school, or the Michigan schools for the deaf and blind. Like it is, those are the entities to which this waiver of privilege applies. So the statute that you were talking about that has the criminal liability is tied to the individual.
Correct.
So, I think that there is a distinction between a waiver that an entity has versus a waiver of privilege that an entity may have versus privilege of the individual. How do you reconcile those two things?
So let's remember who's in charge of school districts. People, school administrators, school officials, superintendents, principals, school board members. It's those individuals that run the school district. And they're the individuals who are responsible for invoking any number of privileges that might be invoked by the school district. And if they make the decision improperly because they unknowingly waived any privilege in as a condition of receiving this money, not realizing the scope of that waiver, not realizing that it might apply to a context that they never contemplated because this language is so broad and so vague, especially the definition of mass casualty event, which we haven't gotten to yet. They are the ones that are at risk of the criminal exposure. Section 161 of the School Aid Act, MCL 388.1761 says, quote, a school official or member of a board or other person who neglects or refuses to do or perform an act required by this act, or who violates or knowingly permits or consents to the violation of this act is guilty of a misdemeanor punishable by imprisonment for not more than 90 days or a fine of not more than $1,500 or both. So it's the school officials, the plaintiffs in this case, who have standing to bring a void for vagueness argument precisely because the language is so vague and it doesn't give them guidance as to whether they're committing a crime or not by invoking a privilege when they may have unknowingly waived it in light of the unlimited contexts in which that waiver could apply. And that's that was the rationale also in the Campaign Finance Act case under Taylor versus Johnson back in 2016, I believe. So that's why this is problematic. It's the school officials that have to make these decisions, and they're the ones that are potentially committing a crime by doing it. So because 31AA subparens 9 is embedded in the School Aid Act, Section 161 applies to a knowing violation or even just anyone who violates it, whether knowingly or not, is exposing themselves to criminal penalty. And so that's why I think it's different, or that's how we reconcile. I think your question was how we reconcile this idea that the school district's waiving the privilege, if they are, and if they're, I think it's still arguable whether and questionable whether they're also potentially waiving individual privileges of individual school officials. But it's the school officials who are the ones.
I don't know that an entity it's permissible for an entity to waive an individual's.
It's causing enough confusion where I've had to answer the question a number of times or address the question a number of times with our clients. But nonetheless, it's the school officials and school board members or any other person are the ones that are exposed to the criminal penalty potentially, because they're the ones responsible and charged with making those choices about when to, for example, invoke a attorney-client privilege in response to a FOIA request or in response to a question during civil litigation during a deposition. Did we waive all those? That's the question because the context is so unclear. So let's talk about mass casualty event if we could. Mass casualty event is defined in subparens 12. And it is, I don't think it's an exaggeration to say it's limitless, it's boundless. And we could be here all day listing different scenarios that may trigger any one of these 4 definitions. The 4 definitions are of mass casualty event. Well, let me back up. It says under subparens A that mass casualty event, quote, means any of the following that occur on school grounds or at a school-sponsored event, end quote. The first one's Romanet number 1 says, quote, an incident resulting in significant injuries to not fewer than 3 individuals. That could mean a limitless number of circumstances, including circumstances that even a reasonable superintendent, educated superintendent might not be able to predict. And so that's why I say, that's just one example why I say they don't know what they're getting themselves into by waiving this privilege, which is the void for vagueness problem. That is the substantive due process violation. This is so
your
broad.
argument that the phrase significant injuries is too broad to be
I
understood?
don't know what significant means. I don't know what injuries mean, what
You
it's
think
meant
that
to
would be
mean.
something that a court could interpret at a later time?
But perhaps they could, but that's not the problem is that right now, sitting here today, there is no bound on this. And we don't have to wait for to be tested on an as applied basis, right? This is a facial challenge on its face right now, as written. You're allowed to examine the language as written, and as written, this whole thing is void for vagueness because it's so vague. right? We don't need to wait for a circumstance to test whether we can construe it to mean a particular thing. Vagueness means it's limitless, it's boundless, and that's what this language demonstrates. So, for example, an incident resulting in significant injuries, not fewer than 3 individuals. Is a significant injury a broken bone? Is a significant injury a concussion? Do I have to have a heart attack for it to be a significant injury?
If
This is
there's an incident that results in, I mean, I would qualify all three of those things as significant injuries, but you'd also have to have an incident that resulted in those
Correct.
things to more than the 3 or more
so
individuals.
so this could be, I mean, we could be here all day coming up with ideas of what could trigger this language. A bus accident on the way to school.
Yeah.
Concussions on the football field during a scrum on the football field, a fight in the stands, food poisoning in the cafeteria, a gas leak perhaps. We could go on and on and on. Is that what this means? I don't know that that's what these means, because I don't know if these are significant injuries or if they're not significant injuries. And it doesn't give fair notice to the school administrators who have to make the call about, can I invoke a privilege in connection with the food poisoning incident? Can I call my lawyers about what our exposure is if there's a concussion on the football field? And am I waiving my privileges by doing it? Or am I more problematic? Am I violating the School Aid Act such that I committed a crime by invoking a privilege if I'm asked about it later on? That's the problem that we're facing. So these are the fact that you could say, oh yeah, that could fit into the language, doesn't solve the vagueness problem. The vagueness problem is that it is boundless, it is limitless, and we don't know and we don't have fair notice of what is legal and what is illegal. Moving to the next Romanet 2, says, quote, an incident resulting in fatalities. I understand it needs to be an incident. Fatalities could mean a whole number of things. MCL 8.3b of the Michigan Compiled Laws says that the use of a singular word encompasses the plural, and vice versa. The use of a plural word encompasses the singular. So any fatality of any kind resulting from any source, is that triggering this? I don't know. I mean, I think we all know what was the kind of impetus of the legislature wanting to provide this language, unfortunately, from school shootings that have happened, but this would encompass anything far beyond that. Fatality could be a single heart attack by a teacher in class. It could be a construction worker on school grounds who has a fatality event. It could be a school shooting, of course. But again, are we giving fair notice to school administrators about what the scope of their privilege waiver is with this language? And we're simply not. Romanet 3 says, quote, an incident that exceeds the normal resources for emergency response available in the jurisdiction where the incident takes place. Your guess is as good as mine, Your Honor, as to what that means. Exceeding normal resources for emergency response. I don't know how we figure out what this means. This could be a false alarm, a prank by a student pulling a fire alarm, perhaps, might exceed normal resources for emergency response. No one's getting hurt under Romanet 3. No one's having an injury. No one's having an illness. It could be a threat online. It could be any number of things. It's also not clear what exceeding normal resources that are available in a particular jurisdiction mean. It could mean something different for, East Lansing, where my kids go to school, or getting something different in Traverse City, where my niece and nephew have gone to school. It could mean different things. Again, not giving school officials who are responsible for invoking these privileges clear guidance as to what is legal or what is illegal. And if they get it wrong, there's a big potential consequence at the end that they've committed a crime. And the last Romanet is Romanet 4, which is, quote, an incident that results in a sudden and timely surge of injured individuals necessitating emergency services. Don't know what sudden or timely surge of injured individuals necessitating emergency services means. They're not defined in the statute. And I don't know that I could advise my school administrator or school official clients as to what that means because it's so limitless and boundless. And so, Your Honor, we could go on and on and on all day talking about all the different scenarios in which this could potentially be triggered. And that's the problem. And you've heard from amicus parties providing additional examples in their briefing as well, which just further demonstrates why this language is so problematic. And again, the fact that a court could say, yes, a particular instance might fit into that language or might not, is not what's in front of you right now. What's in front of you right now is the language as it's written so void that it is a violation of substantive due process. Your Honor, I'm happy to answer any other questions that you might have about the void for vagueness argument that we're presenting. But if you don't, I'll move on to the next point that we wanted to make.
Please, I think you've covered the questions I had.
Okay, great. Thank you. So we've also argued that this creates a unconstitutional condition. I want to make sure that Your Honor understands what our argument is in that sense. It's not so much that it's a separate constitutional claim in and of itself, but it was really, we presented this argument really as a way of getting out in front of this potential idea from the other side that maybe this is voluntary, that, this is, you're opting in, you're choosing to opt in to get this money, and as a condition, you're agreeing to waive any privilege. The problem with it is, and the reason we raise this as an argument is that, and what creates the unconstitutional condition is that the state is not allowed under this unconstitutional condition line of rationale to dangle government benefits in front of folks in exchange for the relinquishment of constitutional protections. And so it's not voluntary is the ultimate point. And this unconstitutional condition doctrine helps us explain why it's not voluntary. And for that reason, we think it isn't voluntary. And so any argument to the contrary that, oh, this is voluntary, that solves all of the constitutional problems is just not supported by this doctrine.
You agree, Mr. Aldridge, that the school districts themselves do not have the constitutional rights that you're talking about. It's
school officials. School officials have constitutional rights, and they're the ones being asked to make decisions about whether to accept this money. School districts are a statutory creature, but they're made up of people who make decisions, and the people are being asked to either take this money and waive privileges or miss out on hundreds of thousands of dollars. And that's the
distinction between officials acting in their official capacity versus officials in their like having privileges on their individual capacity, right?
Well, I don't think they check their constitutional protections at the door by putting their administrator hat on. They still have substantive due process rights. And that's our opening claim, right? They have substantive due process rights. And our point on the unconditional condition piece is that they are being asked to check their substantive due process rights at the door as a condition of either voting to take this money or as a superintendent, if you're delegated authority to do it, to accept this money on behalf of the school. And then they're checking their constitutional rights at the door because now they're being subject to a language that we've explained is void for vagueness in violation of substantive due process rights. Further questions about that piece, Your Honor? Okay. The next separate constitutional problem, of course, is that this provision violates Article 4, Section 24 of the Constitution. All plaintiffs have standing to raise an Article 4, Section 24 argument, and they all have done that here. Article 4, Section 24 is a legislative obligation. It's designed to provide transparency in the legislative process. And what it says, for the record, is, quote, "No law shall embrace more than one object, which shall be expressed in its title. No bill shall be altered or amended on its passage through either house so as to change its original purpose as determined by its total content and not alone by its title," end quote. This title object clause, as it's known, has basically 3 sub rules to it. And each one we've raised in our complaint, Your Honor. The first is what's known as the title object or title body rule. It basically says that, of course, the one object of a statute has to be expressed in its title. The second rule is what's known as a multiple object or single object challenge, which is that the statute itself embodies more than one object, two or more objects that are not congruent and don't have any relation to one another. And this is designed to prevent what's called log rolling of unpopular or controversial provisions with popular provisions. Legislatures, with the idea that legislatures shouldn't have to horse trade those sorts of things in one single bill. They should know what they're voting on in one single bill. And it prevents the hiding of unpopular provisions in a more popular overall bill. And then the third rule coming out of Article 4, Section 24 is what's known as the change of purpose challenge. This is that can't fundamentally change the purpose through the course of the legislative process. And we've raised all three, Your Honor. When you look at the title of Act 15 of 2025, it's long. It's a long title. It's mostly filled with a whole bunch of numbers and statutory provisions that it's amending. But the gist of it is, of course, that, and it says it expressly in the title, that it's an appropriations bill. It's appropriations bill, and it's an appropriations bill that's existed for a number of years. 31AA has been an appropriations mechanism for a long time now. It just so happens this year was the first year the legislature decided to bury into subparens 9 this privilege waiver provision, with zero mention of this second object, of course, in the title. The title says nothing about privilege waivers. In fact, it says nothing about comprehensive investigations as conditions of these appropriations. And these are not just strings that you attach to the condition of, as a condition of receiving these funds. These are fundamentally substantive changes in law and how privileges apply to school districts. That's not just a condition such as, oh, here's how you have to spend the money, or here's when you get the money. Those are conditions that you might have to live with as a recipient of benefits. But to say we're going to also require you to waive privileges in all these unknown contexts is not really just a string that's attached. It's a wholesale second, maybe even third subject, again, which is not anywhere in the title. So a legislature who's asked to vote on this, the public who's asked to understand it, just reads the title. They have no idea that a privilege waiver is potentially being effectuated as a condition.
Counselor, I've albeit gone through the statute very cursorily. It's 152 pages. That's size, I don't know, 2 font. But there are a lot of conditions placed in this appropriations bill, right? Because that is how the funding by the state is done. That these conditions are placed for the school districts to receive money for certain things. And the scope of these conditions is pretty broad, right? We've got audit requirements, we have reporting requirements. I think there are some investigation requirements. There is no challenge to any of these conditions. What makes the gravamen of the waiver and the comprehensive investigation issue fundamentally different from these other conditions that are peppered throughout this appropriations bill?
It's a good question, Your Honor, and I think there's a couple ways to answer it. First, I think just as a baseline, the void for vagueness problem, the fact that it's so vague and limitless, kind of accentuates the problem under Article 4, Section 24, in that it is such a big waiver, unknown waiver, that it's not just a condition about how to use the money. It's not just a condition about being subject to audits. It is a wholesale substantive change of common law, statutory privilege law, that it's not your typical strings attached sort of condition. So I think the fact that it's so vague and so broad makes it something different than what you're talking about, fundamentally different than what you're talking about. The second way to answer your question, Your Honor, I believe, is that our friends on the other side have not explained exactly how the privilege waiver, again, so broad and in so many different contexts, is necessarily related to their stated single object of the statute, which is to provide school support or something to that effect. How the waiver of privileges in other contexts, unrelated to school safety, unrelated to supporting of kids, because again, this language is so broad that we don't know what we're getting into. There's no explanation how waiving attorney-client privileges, how waiving work product, which are like courtroom, these are court rule privileges, how waiving court rule privileges and evidentiary privileges in other contexts like civil litigation, how that relates to the receipt of funding for schools, whether it's for safety or mental health or otherwise. So I think there's a big disconnect between those two things, and I don't see the rational connection between the two. They're just so incongruent that really don't have to do with anything or with one another. Contrast that with a condition that you be subject to an audit for receiving this money. That makes sense, right? The state's going to give you money. We're going to make sure you're using it the right way. So you're agreeing to be subject to an audit.
So then
Yeah.
is your title object clause argument then tied to my finding that the privilege is unconstitutionally vague?
No, not necessarily. I think it contributes to it. I think a vagueness, the fact that it's vague does contribute to the incongruence between this as a condition to receive funds and the overall the stated object of appropriating school aid money. I don't think it's necessarily conditioned on that, but I think it contributes to that position, to that argument. The single object and the title object rules somewhat overlap, right? The case law is a little mushy over the years, and it's, the tests kind of overlap a little bit. But the idea is we have to give folks fair notice of what's in the statute. We don't think burying this really problematic waiver language in an appropriations bill, which, by the way, now, because it's an appropriations bill, is not subject to referendum under Article 2, Section 9 of the Constitution. It is problematic. And this is the kind of Trojan horse problem that the Court of Appeals described in the Keep Michigan Wolves Protected case that was cited. A case I happened to litigate a number of years ago in front of the Court of Appeals. In that case, the court was faced with a statute that was designed to create a wolf hunt in the state of Michigan, you might remember. And we challenged that statute on Article 4, Section 24 grounds. The state had argued that, well, no, this is the Natural Resources Act. It's broad. It's got tons of provisions in it, and it's all meant to protect and relate to the management of fish and wildlife. And they said that adding a wolf hunt to that is consistent with that. But what the court said, interestingly enough, was that another provision in that statute, which guaranteed free hunting licenses to certain military veterans, that was the problematic language and was so incongruent with overall stated purpose of managing fish and wildlife. And the court said there that that single object of managing fish and wildlife is not congruent with giving away free hunting licenses. And if those aren't congruent, certainly in our case, the giving away of school aid conditioned on. Was
that an appropriations bill?
It was an appropriations bill. Okay. They appropriated $1 million, again, to make it referendum proof in that. And that's what, and the court even, I think we cited it to it in our briefing. The court said, this is exactly what Article 4, Section 24 is designed to prevent: a Trojan horse, unpopular provision, the wolf hunt, embedded in other more popular potentially provisions like free hunting licenses to military veterans. And the court said, this is exactly what the constitutional provision is designed to protect against, especially when it's referendum proof. And that's what our argument is here, Your Honor. I mean, if in the wolf hunt case, if those two things are unconstitutionally incongruent, then certainly a privilege waiver of limitless bounds has even less relation to the appropriation of school aid money for mental health and safety purposes. And so that's our position there, Your Honor, on those constitutional arguments. I think it kind of dovetails into the change of purpose argument. Over time, this statute changed from one purpose, which is an appropriations bill when it was first introduced, and then later on throughout the legislative process, this subparens 9 provision, the privilege waiver provision that's at issue, was embedded. And then, of course, we know the history about how this was rushed through the legislature in early October, well past the budget deadline, and well reported in the media that it was rushed through the legislative process. And here we are. And this is exactly how bad law is made when it's rushed through the legislative process. And when you change from an appropriations bill to now a privilege waiver bill that impacts civil litigation, criminal investigations, FOIA, Open Meetings Act, in ways that we all can't quite comprehend sitting here today because it's so vague. That's the kind of thing that Article 4, Section 24 is designed to prevent. And so it's changed its purpose throughout the legislative process to create this second object. This is why I said a few minutes ago, some of the tests for these various sub rules of Article 4, Section 24 are, overlap quite a bit. But for all those reasons, we think it violates each one of those sub rules. And we ask that you declare it unconstitutional for that reason. And we believe, Your Honor, if you declare this privilege waiver unconstitutional, as we've asked, that it's severable from the remainder of 31AA and 31AA subparens 9. The general rule under Michigan law is that an unconstitutional provision should be severed from the rest if it doesn't render the rest of the statute inoperable. And we believe you can do that without rendering the rest of the section, even subparens 9, inoperable. So what we'd be asking you to do is declare just that privilege waiver clause in subparens 9 unconstitutional, leaving the rest to operate as is. And if that's what happens, what does that mean? Well, that means schools can opt in, receive the funds that they desperately want and need, and be subject to a comprehensive investigation if the governor's office orders one after a mass casualty event. But they will be subject to it without having waived any and all privileges in the event of that mass casualty event. They will have preserved their privileges. And so that's why we're asking you to go into this statute with kind of a scalpel as opposed to a machete and just take that provision and declare it unconstitutional, leaving the rest to operate as it perhaps was intended. Finally, Your Honor, our last constitutional challenge is that this provision, this legislative mandate to waive any privilege in any context, including civil litigation, intrudes into the purview and prerogative of the judiciary in violation of separation of powers. As we've all, I think, acknowledged, because of the breadth and vagueness of the statute, the privilege waiver likely includes a waiver of the attorney-client privilege and the work product doctrine and common interest privileges. These are privileges that litigators rely on all the time, that parties rely on all the time in court proceedings. But most importantly, these are privileges that are common law privileges or otherwise created by the judiciary. As we stated in our brief, the Michigan Supreme Court is in charge of court rules, not the legislature and not the executive branch.
But it's not created through a court rule. It's through our common law.
Work product is codified. Work product is a common law privilege. I agree with you. It happens to have been codified by the Supreme Court in the court rules. Sorry. So it's both. It's a common law privilege and now it's a court rule privilege that's been codified. The attorney-client privilege is it's the sacrosanct privilege among attorneys and litigants and parties in litigation. It is a common law privilege. It was created, it's a judge-made privilege. Hasn't been codified in statute in the civil context in Michigan. It's not necessarily codified in the court rules, but is a common law privilege that permeates throughout a lawyer's representation of their clients. And it is used every single day in courtrooms across the state. And who's the gatekeeper of what evidence comes in and what evidence doesn't, what's privileged and what isn't? The gatekeeper is your honor. The gatekeeper is the judiciary, not the legislature and not the executive branch. And when the legislature in one fell swoop annihilates those privileges in an unlimited number of contexts, which we know will end up in civil litigation, they have now intruded into your space, leaving you incapable of making privilege determinations because now a school official has waived on behalf of a school district any privileged in the event of a mass casualty event. That is the definition of one branch of government intruding into another branch of government's power. Your power is derived as a judiciary from the Michigan Constitution, and the legislature can't intrude into it or limit it. Can the legislature create privileges? Yes. They create statutory privileges all the time. Can they eviscerate in an unlimited number of contexts a common law judge-made privilege? I've never seen that before.
Well, in the context of medical malpractice, right? You have the medical malpractice statutes that say if the plaintiff is going to bring a lawsuit, they're going to waive their physician-patient privilege.
Physician-patient privilege is a codified privilege.
It has its roots in the common law, though.
It is, but it is been a codified privilege by the legislature. I'm not aware of any circumstance, Your Honor, anywhere in the country where legislature has imposed a waiver of the common law attorney-client privilege and work product privileges in civil litigation. I'm not aware of any circumstance where that's ever happened. And thus I'm not capable of citing to you a precise case that says in this circumstance, this is an intrusion into the judiciary that violates separation of powers. But that's because I've never seen it before. We've never seen the legislature eliminate the attorney-client privilege or common law privileges. They can create certain statutory privileges, and what they can create, they can take it away, of course, but taking away a common law privilege and making determinations, evidentiary determinations effectively that you would otherwise be making as a judge in that courtroom.
I mean, but the legislature can come and change the common law as they see fit, right? That's their role.
The other constitutional problem here with the separation of powers, Your Honor, is that they've now also in the statute handed the executive branch, the governor, the ability to impose these comprehensive investigations and thus decide when, in certain circumstances, privileges are to be waived. And it's not clear, again, in what circumstances a comprehensive investigation will be required or result, because the definition of mass casualty event is so broad and exceedingly vague. These are constitutional problems that in this separation of powers issue is one that maybe our courts haven't grappled with. But that doesn't mean it's not a constitutional problem. We think it is. And we think that you as a judge and the rest of the judiciary have the constitutional authority to be a gatekeeper within your courtrooms about what is privileged and what isn't. We've cited case law that says it is the job of the judiciary to determine the attorney-client privilege, not the executive branch and not the legislature. And we believe that this just intrudes into that space that is reserved solely to the judiciary under the Constitution. So for those reasons, Your Honor, we separately ask that you declare unconstitutional, that is the privilege waiver provision, because it is a violation of separation of powers. We cited some case law to that effect that explains that this is the attorney-client privilege is something that is determined by the judiciary, and we ask that you follow that rationale and apply it to this somewhat of a unique, perhaps novel issue in front of you. And for all those reasons, Your Honor, we ask that you declare the privilege waiver provision unconstitutional, issue a permanent injunction enjoining its enforcement as written for all the reasons that I've stated here and those in my brief. And if you don't have any other questions, I'll rely on our briefing and yield the podium to my friends on the other side.
Okay, no, I have no other questions right now. Thank you very
you.
much, Counselor.
Morning, Your Honor. Again,
Morning.
Adam DeBear appearing on on behalf of the state of Michigan. I think there's just a few, two really big picture points that I'd like to make before getting into the arguments that were raised by opposing counsel. So one, the biggest problem with this lawsuit, particularly at this juncture, is that it's a facial challenge. And facial challenges are tricky, particularly when there's never been any enforcement of the statute. Up the parties did stipulate that this is ready to be decided under C10 on the law alone, but in reality, when you're looking at facial challenges, there's a lot of, well, what about in this circumstance or what about in this circumstance? There's a lot of speculation and guesswork that needs to happen. And so for plaintiffs to succeed on a facial challenge, they have to demonstrate that in no circumstance would enforcement of the statute be proper. And they may have a point if the enforcement of the privilege waiver came via a third party in a FOIA action about a privilege when there's been no mass casualty event, or it happened in another scenario. But the key area in which this waiver is designed to apply is, for example, if there's an attack on a school. And if there's an attack on a school, the key area that this was designed to cover, it cannot be unconstitutionally enforced so long as that enforcement is an enforcement against the school district that accepted the funding by way of prohibiting that school district from refusing to turn over documents that they claim are attorney-client privileged, or refusing to surrender witnesses. Now, when those witnesses come and testify, as Your Honor picked up on, witnesses are people. And if they have, a valid concern about a right to, not incriminate themselves, well, then they can invoke their Fifth Amendment right to be free from self-incrimination. If they have concerns about a related civil matter, the individual member can invoke their, and they retain an attorney, and if it applies, they can invoke their own personal attorney-client privileges. I think the other big picture point, and I was getting a little bit too into the merits there, is that just because the statute or the waiver is unpopular amongst the schools to which it will be enforced, it doesn't mean it's unconstitutional. And I think that's important, because when you get into the first issue, I think Your Honor picked up on, and it was certainly the state's position, any privilege is clear. It's all privileges that the school districts could possibly use to protect information from disclosure. Your Honor sort of emphasized or stated our point that the school districts have no constitutional privileges because they're governmental agencies, they're public bodies, and sort of just common sense. I think it was one of the Woodman was the plaintiff. I think it was a 2010 Supreme Court opinion. But in any event, the executive branch and the school districts can't, by way of agreement, release the privileges of any individual school district member, any board member, or any school administrator. To the extent those individuals have their own privileges, this provision cannot touch it. And so another thing that's important too, and sort of similar, is that the school districts can only waive the privileges that they hold. To the extent that there's another privilege that would be within the information, within the school district's possession, if it were the case that it required someone else to waive it, well, then they can't waive someone else's privilege or a privilege that belongs to another. I think there are some questions too with respect to the definitions of mass casualty event, and indeed in our principal brief in support of the state's motion for summary judgment, we did at least acknowledge that for the and I can't remember the name of the condition off the top of my head, but the one about exceeding resources within a particular jurisdiction. Well, admittedly, that is a jurisdiction by jurisdiction basis. So there's some that aren't as easy to identify at this juncture, but the principal one, an incident resulting in fatalities, there's no question about that. Enforcement in that condition would be proper. And then the other, the significant injuries one, I think sort of all the examples of potential circumstances that aren't school attacks that plaintiff's counsel offered, for example, food poisoning, bus, those are all things that probably warrant investigations for school safety purposes. How are students at a cafeteria all being subjected to food poisoning? It makes sense to sort of, for the betterment of school safety to get to the bottom of that, and vice versa with bus accident.
How do you respond to Brother Counsel's argument that the language that says an incident resulting in fatalities, that we have the statute that tells us that singular is supposed to be plural, plural, singular. Does that mean that this could apply to a single fatality in a school?
You know, I think, and I haven't done the research with respect to 8.3A, but yeah, to the extent that the legislature is telling us, I suppose, I know in our briefs we said it required plural, but suppose in theory, if the legislature is instructing, you know, the executive and the judicial branches that plural means singular and singular means plural, then yes. And if there is a fatality in the school, particularly if it's you know, well, I guess if there is, it would be in the ambit of the definition. But again, fatalities within a school district are something that warrants a comprehensive investigation to figure out what went wrong and what happened and things of that nature. There's a lot of concern too about the language of the privilege waiver not specifying that it's limited to the comprehensive investigations. Of course, it is the state's position that it is, and I think the reason that it's the state position is the privilege waiver is contained in the same section that identifies the comprehensive investigation, and the immediately following section identifies the purpose and the scope of that comprehensive investigation, right? The governor has to, in the event of a mass casualty event, appoint an investigative entity that will have the power to access records, to interview witnesses, and then ultimately issue findings and conclusions to sort of address those safety concerns that might have led to the ultimate mass casualty event that convened the comprehensive investigation. And just because the statute itself, like all statutes in theory could be written clear, but just because the statute itself doesn't state on its face that it doesn't apply within the context of FOIA, or that it doesn't apply within the context of Open Meetings Act. Well, there's other statutes that govern those, right? The Open Meetings Act specifically gives school boards the ability, so long as they meet the requirements, to enter into closed session and to discuss information, I think it's about, pending litigation with their attorney in confidence. This provision in the an Appropriations Act for essentially one school year, it can't override what's in the Open Meetings Act or what's otherwise in the FOIA, but it can indicate to the school districts that are taking it that in the event of a comprehensive investigation, if you receive a document request or, you know, a subpoena of some form from the investigative entity, that you cannot rely on those privileges in that particular
So
context.
in that scenario, would the minutes from the closed meeting be discoverable and
Yes, within the confines of the comprehensive investigation, not outside the confines of the comprehensive
how do you respond
investigation.
to opposing counsel's argument that under the plain language of this statute, that waiver of privilege is not confined to the comprehensive investigation, that there could be civil litigation or some other circumstance where that privilege waiver would apply?
Well, I think 2 points. One, even if that were the case, I'm not so sure that that renders it unconstitutional.
That was going to be my second question, is that if it was, how
Right.
does that impact the constitutionality
I don't think it
argument?
affects the void for vagueness question. I don't think it affects an unconditional conditions, because the unconditional conditions doctrine only applies to constitutional privileges. And as we've stated, the school districts can hold no constitutional privileges. But going back to your question, and again, I know you could make arguments that as were suggested here, that there is no limit based on the statute. I do think the courts have an obligation to, when a statute is silent in some respect, to give it a construction, and to give it a construction based on the language in the statute. And it's not going to be the case every single time a statute comes before a court that all the questions are answered by the words alone. The courts will have to use those words to best determine the legislature's intent. And the state is not here arguing that it was this provision is designed for a waiver in all forms forever to any entity, but rather that it's a waiver within the comprehensive investigation. But again, if the court determines that that's not what the statute says, again, the state would say that it doesn't affect the constitutionality of the statute. But again, that's another example of why facial challenges are so difficult before any enforcement has happened. The best manner to address a scenario in which the privilege is being asserted or the privilege waiver is being enforced outside the confines of an investigation would be an action at that point in time with respect to those facts and circumstances present, as opposed to sort of, hypothesizing and guess as to what the facts would be in this case. Yeah, and I think we've addressed it, but I know that there's some confusion, at least on the part of the plaintiff's counsel, with respect to administrators not knowing which privileges they can invoke. Well, presumably the administrators operate with the authority of the school board, because the school board is the entity right, that governs the school districts. I can't remember which provision, but it's within the school code, not the State School Aid Act, but the revised school code that says that, school boards are public bodies corporate. They, their boards run the affairs. Well, the administrators can really only be acting under the authority of the school board. So to the extent that the school administrators are concerned about waiving their own personal privileges, there's nothing stopping them from waiving their own personal privileges, and it shouldn't be confused that a
Asserting their own personal privileges.
right, exactly, and it shouldn't be subject to confusion that if the school administrator, on behalf of the school board through which they're employed, or the school district through which they're employed, is waiving their own personal privileges merely because they're responding to a document subpoena within the confines of a comprehensive investigation. They can only act, those administrators, in these comprehensive investigations, with the school board's authority, unless, for example, they are confronted with a document request, identified to them personally, and it says, dear school administrator Jones, please surrender the communications that you've had with your attorney regarding this issue. And if that individual administrator does have their own attorney and there is a legitimate privilege that attaches, this privilege waiver can't touch it just under the plain language of the statute, which only requires the districts, the intermediate school districts, and the Michigan schools for the deaf and blind to agree to waive privileges. There is no individual that has to sign their own waiver of privileges. With respect to title object, I haven't had a chance to review the opinion in its entirety, but I know that this court, Judge Patel, you authored an opinion recently on title object. And I think that the three, really quite recently, I think that the three types of challenges all share one commonality. It's germaneness. If the provision at issue is germane to the overall purpose of the act, it defeats all three of those challenges: title body, single object, and change of purpose. And here, this condition is germane. We pointed to two sources of authority. We have a 1950s Supreme Court opinion. Now, I know things have changed since it might have been 1940s. Things have changed since then, but at least at that point, the Supreme Court had never held that a condition on an appropriation is violative of title object. There was one Attorney General opinion. It's cited in our principal brief. I don't have the citation on hand, but they did find a violation of title object. But that was where an Appropriations Act, which by its very force has one fiscal year of funding attached to it, created a permanent commission. You can't create a permanent commission through an appropriation act, and you couldn't here create essentially a permanent privilege waiver throughout the course of time. This privilege waiver is attached to the funds that are appropriated in the particular act. So I think that if the overall purpose of the State School Aid Act, which is what PA 15 is amending, if that is to support public education and safety of students, then by any means necessary, the legislature can use all means to further that purpose. And the purpose here, obviously, is to get to the bottom of any mass casualty event, which by its very definition is related to safety. The only way for students to be able to grow in school is if they're in a safe environment. And what does this provision do? Well, it creates an investigation that meets the mass casualty criteria, and it prevents the school district from sort of, essentially, even though they're subject to a comprehensive investigation, they can't simply deny all of the document requests for attorney-client privileges. They can't use attorney-client privilege if there's an interview and it's the school district in their official capacity being deposed. It ensures that the state gets more information because in past experiences, investigations haven't gone as well as they could have, and this is what this provision is designed to do. And it addresses that sort of hypothetical scenario that we had in our response to plaintiff's motion for summary disposition, which is the attack on a school. And in that scenario, I think everyone in Michigan would want to get to the bottom of how that attack happened. Are there any conclusions that we could draw as a state to ensure that it doesn't happen in the future? And I think that is totally consistent with the overall purpose of the State School Aid Act, which is funding and support for schools. And because it's germane to the purpose, it defeats each one of those title body or each one of those title object challenges that are set forth in the briefing.
I have a question.
Yes.
And this is something that I've been grappling with because the appropriation bill has so many conditions in it. What is your response to opposing counsel's argument that this condition is fundamentally different than other conditions that are put in there? Like, this is not an audit requirement. This is not a reporting requirement or attendance requirement. This is a waiver of privileges to a comprehensive investigation that is a little attenuated because it's, dealing with something that's unknown and hasn't happened yet. And that in that respect, it's a substantive change.
I think my position would be this, and I'll relate it to audits because I think what is an audit? Well, I don't have an accounting background, but it's essentially a comprehensive investigation. And how does a comprehensive investigation happen? Well, it happens by having, if it's, an audit, there's an auditor that comes and collects all the papers and the documents to conduct a review of everything that happened. And if it's a comprehensive investigation, it's the investigative entity doing the same thing. One thing that would frustrate a comprehensive investigation is if every single document request was met with objections on the grounds of privilege. It wouldn't allow for the comprehensive investigation to be as complete as possible. And admittedly, that may be the case because individuals can't waive their own rights and they have the ability to assert their own privileges. But this ensures as comprehensive of an investigation as we can have into one of the most important areas of school today for anyone who has parents in the schools in the state of Michigan. We want to make sure that it's safe. And so I would say that the comprehensive investigation is very much the same in character to an audit. And the fact that it's tied to specific funds, and we had it in our briefing, but I think the only funds that extend for a period of time are the grants for I can't remember. I think they're in subsections 4 and subsections 5 of the statute. But there's competitive grants for like school resource officers and things of that nature that are subject to statutory work products that go further in advance. They go, I think the maximum is 4 years. But at the end of the day, this is attached to specific funding. So I don't think it changes the nature and scope of the State School Aid Act, which is funded on an annual basis through the Appropriation Act. Rather, it's just another condition, and it's a condition like the audit is, with just another means of making sure that the comprehensive investigation can be as useful as possible to the people of the state, which is why one of the things that they're supposed to do is the investigative entity is they're supposed to make findings and recommendations based on what they've reviewed. And lastly, turning to separation of powers, uh, 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 we made the point in our response brief. I think it's sort of common knowledge that common knowledge. It's commonly understood that the Constitution doesn't require a complete separation of all the branches. And in this case, even though there is a privilege, which the judiciary certainly has a role in, there is nothing preventing the plaintiffs, or not the plaintiffs, but zoom back and imagine we have a comprehensive investigation. There's nothing taking the right of judicial review away from, hypothetical future instances where there's a mass casualty event. There's nothing preventing those individual school districts from saying, you know what, I think the executive is out of bounds or they've crossed the line. We're going to petition a court at this time because we don't think that this is fairly included within the privilege waiver. They still have the right to judicial review. It's not as though the executive can say, nope, you waived the privilege, you have to give me the documents, and you can't complain to anyone about it because you've surrendered everything. There's still the involvement of the judiciary who will be able to, in a particular circumstances with facts that are known, and there's more guidance to be able to make a determination as to, any challenges that future hypothetical plaintiff school district could bring. And so for that reason, and the fact that this is a voluntary waiver and individuals are free to waive any privileges that they hold, it doesn't really implicate separation of powers. And unless the court has any further questions about the state's position, we would just ask that this court issue an opinion finding that the statute is not unconstitutional and dismiss the plaintiff's complaint, which includes the request for declaratory and injunctive relief. Thank you, Your Honor.
Thank you. I'm going to take a quick 10-minute recess to look over my papers and confer before we do the rebuttal, just so that if I have any questions, we can. I'm sorry, did you have argument as well, Miss?
All due respect, I know it's, but I would.
Yes, please go ahead.
Thank you. Tony Harris again on behalf of the Michigan Department of Education and Superintendent of Public Instruction. So as I was saying, I really wasn't anticipating having a lot to say today, and I don't have a lot to say, but I wanted to address a couple of items. And before I get into the request for relief, I just wanted to address one point that Mr. Eldridge made at the beginning of his oral argument. Mr. Eldridge stated that the 31 AA sub 9 language is so eye-poppingly bad that MDE and the SPI are not defending it. And I just want to clarify for the record, any misperception or misconception that that is the reason for MDE's and the SPI's position. There, as we explained in our opening brief, MDE and the SPI will administer the statute as it's been interpreted by the court. They don't take a position on it being good or bad. That's not their role. They didn't have any involvement in, anything tied to this provision in the language. So I just want to make sure.
I definitely chalked it up as a vigorous advocacy on behalf of the plaintiffs and not as a concession by the MEDC.
Wonderful. Okay. And so then to the request that they made that the court, if the court upholds the privilege waiver, to then change the rescission deadline from December 30th to some unknown date out in the future, 30 days after all appeals are resolved. As we mentioned briefly in our papers, that's essentially asking the court to unilaterally amend the parties' agreements. In our first status conference, everybody was interested in whether MDE could make any additional space for schools to opt in. And so the parties discussed the issues and it really MDE in the language of the statute has the discretion for all form and manner for how it will administer the opt-ins and so forth. And so the parties negotiated a specific deadline for schools to opt in and negotiated specific deadline and criteria that the schools must meet in order to rescind. And that deadline was specifically set and agreed to by the parties unconditionally as December 30th. It wasn't, there was no negotiation about whether the parties the deadline would be changed on which, the court ruling in favor of one or the other. It was a hard deadline that we agreed to. We submitted it in a stipulation. The court ordered it. It's also incorporated into the stipulated set of facts. And so to ask the court to take a position on that deadline and actually to change it is outside of the court's authority. The parties entered into a binding contract. And I know that council made the argument they didn't make the argument, they made the request in their initial motion. They didn't make an argument as to why, as to any supporting, any support for their position. And so we would ask that the court deny any request like that because it's not within the authority of the court. I would, and I don't want to take up a lot of the court's time on this issue because I know you're really focused on the constitutionality, but I did want to raise this and make the argument on that contractual issue. So thank you.
Appreciate it.
All right.
Okay, thank you very much.
Thank you.
We will take a short, let's say 10-minute recess, and then I will be back. Thank you very much. Please be seated. Okay, we are ready to continue. Mr. Eldridge, did you have rebuttal?
Yes, Your Honor. Your Honor, I'd like to just address a few points raised by my friend on the other side. My friends on the other side might address a couple of the attorney's statements. I'm going to try my best to not repeat myself and only address a couple of the points that were raised that I think just warrant a little bit of refinement on our end so that you're understanding exactly what our position is, because maybe there's some confusion. I think the best place to start is a reminder of what the case law says is the test for a void for vagueness challenge. And remember, does the statute provide fair notice to individuals about what is prohibited conduct versus what is permissible conduct? Stated another way, what is legal versus what is illegal under the provision. And our position, to be clear, is that this is appropriately subject to a facial challenge precisely for that reason. It is necessarily because there are no circumstances in which this could be constitutional that is because it is void for vagueness. The void for vagueness aspect of it is the constitutional violation. And so because of it, there's no circumstances under which it could be considered constitutional, even if we could conjure circumstances that say, well, this would be okay in that circumstance, or this is covered by this language. And because this is covered by this language, therefore we're confident that nothing else is. The point of the facial challenge under void for vagueness is that you can't define appropriately and provide notice appropriately to the people who are charged with making decisions on behalf of schools of what is confined in that box that this statute tries to shape. And I'm fairly confident Your Honor is not going to be issuing a decision that defines that box, the four corners of what this provision means in her ruling, such that you're going to give clear guidance to everybody that we all know going forward what's in this box that's maybe covered and what's outside of this box and not. And that is the problem. The fact that because we have, even if we have a larger box, if we don't know what's in that falls inside the box versus what falls outside of the box, it's still void for vagueness, even if it's a big box. The size of the box doesn't matter. It's whether we could provide notice of what fits into the box versus what doesn't fit into the box. Mr. DeBear made a couple of references to the fact that, certain things might warrant an investigation. Well, that's not what we're here to discuss, whether an investigation is appropriate in any one of these circumstances. Again, we're here only asking you to declare the provision unconstitutional because it's void for vagueness, because it violates Article 4, Section 24, and because of separation of powers. Whether a circumstance warrants an investigation is not in front of you, nor is it really germane to any of the arguments that we're making. Another thing that I heard that I want to address, Your Honor, is that it sounds as if Mr. DeBear still wants to confine this to a comprehensive investigation, meaning when I say this, confining the privilege waiver to a comprehensive investigation. The statute simply just doesn't say that. It says you're waiving a privilege in the event of a mass casualty event. And then, oh, by the way, you're also subject to a comprehensive investigation if the governor wants to order one. The language, I don't see anything in the statute that says the privilege waiver, I'm sorry, is connected to the comprehensive investigation only. And that would suggest that they're taking the position that it doesn't apply to civil litigation, that it doesn't apply to FOIA, that it doesn't apply to Open Meetings Act or audits or criminal investigations. But I don't think I heard him draw that line. He just seems to want to be focusing this back to the comprehensive investigation. And unfortunately, the language doesn't support the argument. The issue of whether the school districts are waiving individual privileges, was addressed in your exchange with Mr. DeBear, and I want to make sure we're clear about something. I think there is some legitimate question as to whether this statute attempts to do that, but the plaintiffs do not need the court to conclude that school districts are waiving individual privileges under this language for us to succeed in this lawsuit. Because remember what our void for vagueness argument is really about. It's that school administrators, school officials, board members, and any other person who are responsible for invoking privileges and who are in charge of these schools, they don't have the direction that they need, the notice that they need to know what is okay in that regard and what isn't. And that is the constitutional problem. We don't need the court to conclude, for us to prevail in that regard, we don't need the court to also conclude that the school district is waiving individual privileges. The constitutional right of the individuals that's at stake is the right to substantive due process, just like it was in the Taylor versus Johnson case that I cited before. That was the constitutional infirmity, not that school districts are potentially being asked to waive individual privileges. So I just want to make sure we're abundantly clear on that, Your Honor. I did hear, counsel say something about, well, in that regard, well, individuals can certainly lawyer up and find their own lawyers, and that's still intact. But if that's how we're reading this, and this language is left to stand as is, it's going to force school districts in countless circumstances, maybe just out of abundance of caution, to start hiring lawyers for their individual administrators to make sure that those privileges and those privileged communications are protected. And can they share those lawyers with the school district? School districts oftentimes hire lawyers to represent the school district and individual administrators if they don't have a conflict. In that circumstance, can the individual school administrator, after accepting this money on this condition of waiving any privilege, still invoke the attorney-client privilege if they share the same lawyer, which happens all the time, under, say, a common interest privilege? Can they still invoke and rely on those privileges, or has the school district, because of their waiver of privilege, somehow effectuated a waiver of privilege of them? I don't know the answer to that under this language. I understand Mr. DeBear's position that school districts can't waive that, but they could certainly share attorneys on the same issue. And now we're back into square one of what have we waived and what haven't we waived.
Would that just create a conflict situation?
It's not a conflict. It wouldn't
That
be.
would then require separate representation
I
for
don't
the
see how
individual?
I don't see how it's a conflict. Conflicts are if they have different positions or they're pointing fingers at one another.
Well, if
a
there
school-
if there's a waiver of privilege in one and not in the other, there might be a conflict there.
I don't see how that creates a legal conflict from an ethics standpoint. They can still have the same lawyers. But the school official is there as an individual with their own lawyer. Are they going to be accused of violating this statutory provision if they invoke the attorney-client privilege in that situation and say, well, that's my lawyer too? And that's the concern. Again, what fair notice are we providing with this statute? And the answer is none under the void for vagueness doctrine. This is the problem. No individual school administrator or official or board member should have to wait for an as applied challenge to figure this out, what's appropriate and what isn't. Because at that point, it might be too late. They may have already committed the crime under section 161 of improperly invoking a privilege that someone else, the executive branch, for example, during an investigation or in civil litigation, concludes you improperly invoked that privilege. So that's really the problem. Just another example as to why this is so limitless and without proper notice to the folks who are in charge of these schools, forced to make these decisions. One other point that I wanted to address, Your Honor, and I'm getting close to finishing my list here, is I think I heard Mr. DeBear concede that the privilege waiver or state that the privilege waiver is somehow limited and it can't be waived in perpetuity under this language. That is not what this language says. Statute does not have any temporal scope on this privilege waiver. It says you're agreeing to waive any privilege That could mean a privilege now, a privilege tomorrow, a privilege next year, maybe even a privilege last year in the event of a mass casualty event. There is no language that ties it to just the year in which you're receiving these funds. If it did, if the legislature meant to do that, it would have said so. It would have said, you're only waiving privileges that are tied to this language. It's not what it says. It says you are waiving any privilege in the event of a mass casualty as a condition of receiving this school aid. So while Mr. DeBear's interpretation of this, that this doesn't, that somehow this is limited in temporal scope, I don't see it in the statute. It's not there in the statute. That would be adding words to the statute that are not there. And of course, that's not our jobs, and that's not the court's job to rewrite the statute or add words that don't exist in an attempt to try and limit its scope. On the separation of powers piece, I heard Mr. DeBear say that somehow, this doesn't impact the right of judicial review. Well, that's not our separation of powers argument. Our argument is not that somehow this limits the right of judicial review of any circumstance that might be challenged in court. Our separation of powers, I think I hope I was clear, is that the legislature is effectively taking the gatekeeping role of evidentiary rulings and about privilege and admissibility and things of that nature away from the judiciary and civil litigation that could ensue after a mass casualty event. Because again, this is not connected to and limited just to comprehensive investigations. But our argument is that it's taking that gatekeeping role away from you and intruding into the judiciary by doing so. So I just wanted to make sure we're clear about that. We're not arguing that somehow you're not entitled to judicial review as a component of our separation of powers argument. Finally, Your Honor, I want to address Ms. Harris's comment, not about the eye-poppingly bad language piece, but about the relief requested. First of all, Your Honor does have the authority to enter an order that grants the relief that we're asking for. And the fact that we also entered a stipulated order doesn't change that fact. You can amend that order anytime you want. You're the judge. You can issue any equitable relief that you think is appropriate. And let's not forget, we're asking for declaratory relief and injunctive relief. Both are equitable remedies, and you're allowed to exercise your equitable powers to effectuate an appropriate remedy. But I want to put it in a little better, clearer context. If you rule against us and let this language live on as is, and we appeal, and we prevail on appeal, that appeal is likely going to not be resolved until after January 1 of 2026. It would be unequitable or inequitable to, and if we prevail on appeal and the Court of Appeals or the Supreme Court declares this unconstitutional, it would be unequitable if somehow our school district clients weren't entitled to still receive funds that were tied to an unconstitutional provision. And so that's all we're asking would be the court to exercise its equitable powers to say if there's some kind of appeal and this were to come back and be declared unconstitutional, that there would still be an opportunity to receive the funds and not be subject to the privilege waiver that would have been declared unconstitutional. So that's the last point I think I'll make, Your Honor. I'm happy to answer any other questions you have. I think we may have exhausted the conversation at this point, but I'll leave that to you.
It's been great conversation. Thank you very much. I don't have any questions.
Thank you, Your Honor.
Okay. Mr. DeBear, do you have any rebuttal that you'd like to offer, or are you?
The only thing that I'd state and sort of echo from our previous conversation in relation to what Mr. Eldridge just said, it is the state's position that the privilege waiver is limited to the confines of the comprehensive investigation. But again, because the entities that are signing this privilege waiver don't have the constitutional rights that individuals have. They're the school districts and the intermediate school districts in the Michigan schools, for the deaf and blind. they don't have the substantive due process rights that individuals have, because again, the Bill of Rights, as we stated in our I think it was our motion for summary disposition, those are designed to protect individuals from government action. They're not designed to protect government from government action. It is a voluntary waiver. They don't have to accept the money, but if they do, they need to be prepared to waive privileges in the extent of a comprehensive investigation. If this court thinks that it's a broader scope than that, it doesn't impact the constitutionality of the overall statute. And again, we just ask that the court grant the state's motion for summary disposition, dismiss plaintiff's complaint. Thank you.
Okay, thank you very much. Ms. Harris, do you have any other comments? Okay.
I'll be brief. I would just like to go back to what I mentioned earlier without being repetitive, but also go into a little bit more detail. As we explained in our brief and in the cases we cited, a stipulation is an agreement or a concession by the parties as to a fact, or and it's to be construed like a contract, and where the language is unambiguous, is to be enforced as written. And here the court entered the stipulated order, not only as to deadlines, but also stipulated facts. The court entered an order. Those are contracts. They are binding as to the agreements between the parties, and the agreements specifically as to the deadline to opt in and the rescission deadline and the effects of the rescission deadline. So for example, well, before I get into the example, the parties negotiated these terms. MDE is authorized by statute to establish the form and manner of administering the opt-in process under subsection 31AA3. And MDE negotiated those deadlines and those terms. So what plaintiff's counsel is requesting is that the court change the deadline in a document as though it can just be turned on its head. But I apologize, I didn't bring it. Specifically, the parties agreed that MDE will allow a school that opts in, and this is section 3 in the stipulated order regarding deadlines. The parties agreed that a school that opts in and agrees to receive funding under subsection 3 by the December 4th deadline can rescind the agreement under certain conditions. They have to notify MDE by December 30th, a minute before midnight, in the form and manner determined by MDE and published on its website. The school agrees that MDE may recoup all funds paid to the school under that subsection by deducting amounts from future state school aid payments until all the funds are fully recouped. The parties agreed that under this stipulated deadline agreement, that the school will agree to waive all rights to challenge MDE's efforts to recoup those funds. These are all terms the parties agreed to. It's a contract. Those meant something to MDE. When MDE agreed against its own interest, because it's cutting itself short on time to process almost 1,000 of these opt-ins, MDE agreed to give more time to opt in under certain conditions. Those are the parties' agreements. Mr. Eldridge cites no authority for this court to upset the parties' contract, a stipulation that amounts to a contract that the parties negotiated through attorneys and everyone agreed to. And I would also note that, you know, the effect of this request for some indeterminate date, 30 days from the last decision on an appeal, could have and likely will have unintended consequences. For example, Mr. Eldridge is optimistic to think we would get a decision from a court of appeals with even in January. I mean, this could go on for months. It could extend into the next fiscal year, and that would create issues. It could extend in 2 fiscal years by the time, let's say, if they get an unfavorable decision in the court, in this court, and then they get an unfavorable decision in the Court of Appeals, they still have the opportunity to try to get before the Supreme Court. These are not going to be done in a matter of months. And so MDE could be left, could be faced with, let's say, 2 years down the road, 2 fiscal years later, figuring out the schools who opted in by December 30th of this year are now opting out, let's say in June of 2027. And MDE has to track those funds, recoup those funds in a separate fiscal year, which is, from a government perspective and a fiscal perspective, not a simple task. It's a complex funding scheme. And then what they would have to do is gather up all those funds and figure out at that point, redistributing them to the schools that did not rescind. Because what happens under the statute is all the schools that opt in, MDE gathers up all the per pupil data, and the amounts are distributed based on that. So if MDE recoups funds from schools that rescind their opt-in, it will recalculate the per pupil amount and redistribute those funds to the schools that remain. And this is not a simple task. This is why MDE wanted at least a month between the November 30th deadline that it originally set and the December 30th deadline that the parties agreed to without condition on who wins or who loses at this level or any level in the hearings. And then it also creates a condition where schools that have opted in, and if we have an extended indeterminate rescission deadline, let's say that a school that opts in experiences arguably a mass casualty event. Do they then suddenly get to rescind their opt-in so they're not left with facing, with being subject to the terms that they've agreed to opt in while they sit and wait on the sideline and get ready to pull the lever to rescind if they're somehow stuck with it? That creates a problem. How is that enforceable? The court's order in changing the rescission deadline will leave MDE and the schools in this situation, and it could be over the course of several months or even years. I would also say, even though I'm not here to speak on behalf of the schools, the situation, it's safe to assume that every school district is making a decision, its best decision on likely legal advice on the strategies and the exposure for opting in. And they have to make that same decision for whether they're going to rescind by the deadline. And once they make that decision with the funds that they're going to get by December 31st, they may be making that decision based on getting all of their funds by December 31st. They could then be stuck in a situation down the road where the rescission deadline is moved, schools rescind, money is recalculated, the schools get a new tranche of money that they weren't anticipating. Again, unintended consequences and impacts that maybe they didn't want. Now, do those schools want to be able to rescind because now they're stuck with a situation they weren't planning on, weren't intending? To have a new tranche of money that they didn't strategize for. So it's an important issue, although it's, outside of the constitutional issue, this new request for relief that's contrary to what the parties negotiated, there's no basis for it. Mr. Eldridge did not address the court's authority and how the court would have equitable powers to amend the parties' negotiated contract. So unless you have any questions for me, Your Honor.
I do not. Thank you very much. I
Thank you.
appreciate it. Okay, with that, thank you, counsel, for a wonderful argument. I appreciate it. I will be working on getting an opinion out as soon as practicable. Is there anything else that we need to discuss today? Okay, thank you very much. All right, thank you. I want to thank Ms. calendar. Thank you very much for your services. We really appreciate it. Thank you, Vince Ganal, for providing great safety and administration of the court. I appreciate all of you and have a great rest of your day.
Taking photo of flags, now then.